Okay guys, so we're going to continue our video series here. We're going to do chapter 6, which in your textbook is page 209, Dower, Curtesy, Wills, and Dissent here. So what we're going to talk about in this chapter is things to do with marital rights, like Dower and Curtesy, the right of possession, and just in general wills and everything. So this will be page 209 in your textbook. So the first thing we'll start off with here is Dower. And Dower is the wife's 1/2 interest in every single property that her husband owns, as long as they were both married and the property was acquired prior to May 28, 1980. So as an example, they didn't have to be married when the property was acquired. Let's say the husband bought 10 properties in the 1960s, and then they got married in 1972. Even if the husband's wife, let's say the husband's name is John and the wife's name is Mary, even if Mary's name the day they get married is not put on any of those deeds, she would automatically still have a 1/2 interest in every single one of those properties. And her 1/2 interest doesn't mean she really owns the property necessarily, but what it does mean is that when he goes to sell any of those properties, she has to sign off on the sale. And if she won't sign off on the sale won't go through. So Dower is the wife's 1/2 interest in every single property that her husband owns, as long as they had gotten married prior to May 28, 1980, and the properties were also acquired prior to May 28, 1980. After May 28, 1980, these things don't apply, and we'll talk about that in a little bit. That's called the right of possession. Curtesy is the same exact thing as Dower, except it's the husband's 1/2 interest in every single property that the wife owns, as long as they had gotten married prior to May 28, 1980, and the property was also acquired prior to May 28, 1980. So again, and to give you another example, let's say the husband's name is Joe and the wife's name is Jane. If Jane bought 10 properties in the 1960s and then they got married in 1975, let's say, Joe would automatically have a 1/2 interest in every single one of those properties. That 1/2 interest we call a Curtesy interest, a Curtesy right. So Curtesy is the husband's 1/2 interest in every single property that the wife owns, as long as they had gotten married and also the property was acquired prior to May 28, 1980. Now, new interests of Dower and Curtesy stopped being created after May 28, 1980. It doesn't mean they're not still around today, though. So to give you an example, let's say Joe bought 10 properties in the 1960s, and he got married to Jane in 1975. Jane would have a Dower interest in those 10 properties. If Joe still owned those 10 properties today, and he still happens to be married to Mary, let's say today in 2019, when Joe goes to sell those properties, Mary has to sign off on those deeds. Even though he bought the properties in the 60s, they got married in the 70s, and they still own them today in 2019, his wife would still have to sign off on those deeds when the property is sold to forego what's called her Dower right. Her Dower right basically allows her to say, I don't want you to sell the property, is really what it allows her to do. Just as Curtesy would, basically give the husband the right to, put the kibosh on a sale that his wife's trying to sell, that he has a Curtesy interest in. So Dower and Curtesy still does exist today. It's just that no new Dower Curtesy interests were created after May 28, 1980. After May 28, 1980, now the marital rights affecting a residence are called the right of possession. So for example, let's say I bought 30 investment properties last year, and I happen to get married this year, and my wife's name is not on any of those deeds. The only one that she would automatically get a 1/2 interest in when we get married is the principal matrimonial residence, which is really just the residence in which we live at. So the difference is the Dower and Curtesy apply to all properties. The right of possession says that your spouse only automatically has 1/2 interest in just the principal matrimonial residence. Now, nothing would stop you from putting your spouse's name on all those deeds that you have, but the only one your spouse has an automatic 1/2 interest in under the right of possession after 1980 is just the principal matrimonial residence. And getting back to Dower and Curtesy, these Dower and Curtesy rights cannot be sold, cannot be transferred, cannot be conveyed. They're just for you and you only. Your Dower and Curtesy rights are just for you. They hold no value. You can't sell them. They're just for you and you only. And if they were to ask you, is there any type of ownership where Dower and Curtesy would not apply? Joint tenancy. Dower and Curtesy would not apply to joint tenancy. So if they were to ask you, where does Dower and Curtesy not apply, what type of ownership, it would not apply to properties owned in joint tenancy. So let's turn the page here. Let's go to page 210. 210, we'll go to the right side here under wills and dissent. So just some terms that go along with wills here. So in general, first and foremost, this is a lot of vocab, so you're just going to have to bear with me here. But for starters, they might ask you, when does a will take effect? A will takes effect upon death. A will means absolutely nothing until somebody dies. So if they ask you on the test, when does a will take effect? A will takes effect upon death. The next bolded term you'll see there on the bottom right of 210 is law of descent. If you die without a will, in other words, you die intestate, that means you die without a will, your property is then transferred by what we call the law of descent. And what the law of descent means is who's most closely related to me. And that typically goes spouse, children, grandchildren, the next of kin afterwards. But in general, the law of descent basically, again, tells you who's most closely related to you. That is how your property is transferred in the case of what we call intestacy. When you die intestate, that means you die without a will. And bottom right here of 210, the last bolded term on this page is probate. So what is probate? Probate is a process of distributing an estate. When somebody dies, all of their assets go to this fictional place called their estate. And then their estate is distributed either according to their will, if they have one, or according to the law of descent, if they don't have a will. And that process of distributing somebody's estate, we call the probate process. If you guys have ever heard the term, they're probating the estate. That means they're going through the process of distributing the estate. So probate is really the process of distributing an estate. And then if you go to page 211 here, just more bolded terms. We're going to go through these one by one. But the first one here is testate. You die testate, you die with a will. As I said earlier, you die intestate, you die without a will. Again, you die testate, you die with a will. You die intestate, you die without a will. Then you'll see these terms like testator and testatrix. As a general rule of thumb, if you end these words in IX, it means female, and OR means male. So a testator is a male who makes a will. A testatrix would be a female who makes a will. So again, a testator is a male who makes a will. Testatrix would be a female who makes a will. Let's say there is no will. Because if there is no will, you're not going to have a testator. The person did not die testate. So the court's going to have to appoint somebody to distribute that estate. The person that they appoint, you'll see bolded here, is called an administrator. An administrator is court appointed in the case of intestacy. So if somebody dies intestate, the court will then appoint an administrator, and the administrator's job is basically to distribute that estate as they see fit. And usually it's by that law of descent. They're going to look for who's most closely related to you. But if you die testate, you die with a will. In your will, you're going to name somebody to carry out the directions of your will. The person that you name is called the executor. So the executor is the individual who is named in the will to carry out the provisions of the will. So again, the executor is the individual named in the will to carry out the provisions of the will. Now, a question sometimes they ask about this that confuses people. They might say, which of the following would not be involved with the will? And the answer is administrator. An administrator only comes into play when somebody dies intestate. If you die intestate, they appoint an administrator. So, again, you would only have an administrator if there's no will involved. And another bolded term there, the last bolded term in that first paragraph on 211 is escheat. If you die in escheat, that means that you died without a will and without heirs. So if you die without a will and you die without heirs, who does your property then go to? It goes to the government, and we call that escheat. So escheat is to die without a will and without heirs. Then property goes to the government, and we call that escheat. And then bottom left here of 211, some more bolded terms. The terms, the first one here is a devise. A devise. A devise is a gift of realty through a will. So if you gift property to somebody through a will, we call that a devise. So a devise is a gift of realty through a will. Then we have a codicil here. Codicil, codicil. To be honest with you, I still have no idea how to pronounce it, but I just call it a codicil or a codicil. So a codicil is just a revision made through a will. So if they were to ask you which of the following best describes a revision made to a will, it's a codicil, or however you want to pronounce it. But again, a codicil is a revision made to a will. And then top right here of 211 talks about a holographic will. And I'll never understand why they call it a holographic will, because it's completely handwritten, it's unwitnessed, and they are valid in New Jersey. So if you had a completely handwritten, unwitnessed will that's valid in New Jersey, we would simply call it a holographic will. So again, a holographic will is completely handwritten, it is unwitnessed, and it is valid in New Jersey. And then bottom right here of 211 talks about alienation. So alienation is a very broad term, something that we're going to go over more in detail in Chapter 14, the mortgages chapter, because we have this thing called an alienation clause. But just to define it real quick, what alienation means, the term alienation means simply to convey or transfer property. So if you convey or you transfer your property in any way, shape, or form, it's broadly defined as an alienation. So if I sold it, if I happen to will it to somebody, if I were foreclosed on, anytime I'm conveying or transferring my property, the broad way to describe that is alienation. Again, alienation means simply to convey or transfer property. So Chapter 6, short chapter review here. Those are all the main topics to take away from it. As always, if you guys have any questions, feel free to email me with questions going over this. My email is kylekovats@gmail.com. Thank you, guys.